I'd like to call to order the January 5th, 2010 Planning Commission of Radnor Township meeting. I'd like to first start off the meeting with the introduction of two newly appointed Planning Commission members. We have Susan Stern and Walter Kunda have just been appointed by the commissioners to serve. Susan is serving the four-year term, which was up from Carrie Lawler. And I believe it's Skip. Do you go by Skip or to Walter?
After this meeting, I'll go by Skip.
Okay.
Because I think everyone knows me in the township as Skip.
Okay. Skip is filling the vacancy left by Don Curley, who is now one of our commissioners. I'd actually asked both of you, I contacted you earlier and said I'd like to ask you to just tell us a little about yourself. Going with the proper etiquette, we'll go with ladies first. So Susan.
Thank you, Mark. I'm Susan Stern, and I've lived in the township for just under 10 years with my husband and 3 children. And I graduated from the University of Pennsylvania with a nursing degree, which has nothing to do with planning. But I work as a business manager for a church in Gladwin, and through my work there became involved in a land planning and subdivision work, and became very interested in it, and am pleased to be here. Thank you.
Thank you.
Hi, I am a resident of the township for 32 years with my wife, Kate, who is also a teacher at the high school, and my 2 children, who are both graduated Radnor High School and have gone on to other good things. I am also a lawyer and a businessman. I have taken 5 different projects through development in Upper Marion Township, and I've been the president of a 50-employee company that I recently sold, and I'm looking forward to the opportunity to be part of this board and help in any way I can the township.
Thank you, and welcome. I'd now like to turn over the meeting to Matt Marshall. He is the chair of the nominating committee, and I will hand it over to him.
Thanks, Mark. Aside from introducing the new members of the Planning Commission tonight, we're also giving a look at our leadership going into 2010. And just to give everyone a little background, every year upon new appointments, we also select our chair and vice chair positions for the Planning Commission. This year, the nominating committee was comprised of Julia Hurl and Doug McCone and myself. We started the selection process in December 2009. We polled the sitting members of the Planning Commission to find out their interest in serving in leadership positions. And we were actually given 3 names. We have narrowed that list to 2, and it's my pleasure to announce tonight that Mark Rhodes will remain as chair of the Planning Commission, and replacing Don Curley as vice chair will be Ed DiMarcantonio. So thank you both for your willingness to serve, and look forward to a productive year.
You want to do a motion for it?
Yes, and I guess to be official, we'll have to have someone second those nominations, and then we'll have to vote on it as a board.
I second.
Great. So we'll have we'll have a motion, which is the appointment of Mark Rhodes as chair and Ed DiMarcantonio as vice chair, and that will become effective as of this evening, January the 5th.
Very good.
Okay?
All in favor?
Aye.
Aye.
Very good. Doug comes across. Very good. Well, thank you, guys.
Thank you.
One thing I would like to add before we get on with the normal business, as I alluded to, Susan is replacing Carrie Lawler. There was some misunderstanding whether Susan was going to be appointed at this meeting. So Carrie had volunteered to come to this meeting if need be, and obviously I was going to give her the proper send-off at that point in time after attending this meeting. Unfortunately, Susan's appointed, but we now have too many planning commission members. But I did want to publicly thank Carrie Lawler for all her service. Carrie served on the planning commission for 8 years. During that time, she was a liaison to the EAC of Radnor. She was involved in many other committees. She is very devoted to this township, and I think we all owe her a lot of gratitude for everything that she's done for this township. I spoke to her today on the phone and thanked her. She wanted to thank all of us. She enjoyed working with all of us, and especially Dan and Sue. And I hoped that she would return to some sort of advisory board or other position within the township, because she is a very valued asset for this township. So just a big thank you to Carrie Lawler from all of us. With that, we'll move on. We need to approve the minutes from the December 8th, 2009 meeting. Are there any comments, questions, revisions to the minutes of the December 8th, 2009 meeting? Do I have a motion to approve the minutes of the December 8th, 2009 meeting?
I'll motion to approve. Second.
Second?
Second.
All in favor?
Aye.
Any opposed? Motion carries.
I was just going to abstain.
It's fine. Thank you. We'll now move on to the item number 3 on the agenda, which is an ordinance amending Article 28 of the Wireless Communication Systems of the Code of the Township of Radnor, revising sections 280-161 through 280-171. We have with us John Riley, who I believe will do part of the presentation this evening. This has been before the Planning Commission on 2 prior occasions. It was before us on July 6, 2009 initially, I believe. It was back before us on September 8th, 2009, where we had made recommendations and further revisions. Since then, it has had further revisions. It has gone to FCC counsel down in Washington, D.C. for his review. It has gone to our solicitor for our review. In our packet, when you came on board, yes. In one of our packages, you might have the December 3rd, 2009 letter from our solicitor, John Rice, commenting on it. I believe the Citizens Communication Council had a copy of this and have also made revisions in accordance with this. So the latest version, which was distributed in the past couple days, which I believe every one of the Planning Commission members has been reviewed by all councils and is now up for our hopefully final review, and then it will move on to the commissioners if we deem it necessary after tonight. With that, John.
Thank you, Mr. Chairman. Good evening, everyone. To those I've seen before, Happy New Year, and to the new members, Happy New Year as well. And in the interest of sort of giving everyone a context of where we are, I'm going to just go over briefly why it is, again, we're doing what we're doing, and then get into the substance of the changes that we're talking about. As Mark noted, we've been before your group in July and in September, and in response to questions and comments that we've received at both of those meetings, we have prepared the revisions that you have before you this evening. Taking a step back, the Citizens Communications Council was asked in early 2009 to review the applicable code sections relating to wireless communications facilities in the township, and to suggest where we considered appropriate revisions or updates to those provisions. The purpose for the update is, again, to keep us current. There have been certainly many changes in the market and in the wireless space since these regulations were first enacted some time ago, and the goal here is to keep current, but also not do a wholesale rewrite of the code. There's much in the code which serves us well, and it was deemed unnecessary to take a full red pencil to the entire code, but just to tweak where necessary. I apologize. I should point out that Bruce Wilson, who is a member also of the Citizens Communications Council and a member of the drafting subcommittee that has prepared these amendments, is also with me here this evening. With that as background, let's get right to the substance of the changes that we're proposing. And in the revised versions that you have before you, there are a great number of lawyer sort of tweaks and clarifications that are intended to make clear or clear up any perceived ambiguities that might be in the current code. What I'm going to focus on this evening are the really substantive changes that have been proposed since last we met in September. The first section is affected section is section 206.164A, which you may recall there's a division between wireless communications facilities that are constructed outside the public right-of-way and those facilities that are constructed within the right-of-way. Section 260.164A relates to wireless communications facilities that are outside the right-of-way but are attached to other structures. Think of an office building, an apartment building, something like that. Not a cell tower as you might think of it, but just some other structure that's in existence. The changes to the section propose that wireless communications facilities, and again, think antennas, things like that, may be affixed to structures that are in excess of 60 feet in height in the designated zoning classifications that are described in the code. And I should point out, and I apologize, I noted this last night while preparing this this presentation. We had discussed at our September meeting excluding planned zoning classification plan institutional from the delineated zoning classifications that would permit the construction of these wireless communications facilities to existing structures.
You say exclude them?
Exclude.
Now, there's planned institutional?
Planned institutional, the first set of revisions, we added planned institutional based on the discussion that we had in September. We're now proposing to take those out.
Okay.
So think any of the planned institutional uses would be educational facilities, similar uses of that nature. Our conclusion on the drafting committee was that we were adding, very little potential uses, and good reasons were raised at your September meeting as to why we should not have added that. So that should have been deleted, and it's not reflected as deleted on the draft that you have, but that will be the proposal going forward.
Just a point of clarity,
Yes,
what is the number of this section? Is it 206 or 280?
I'm sorry, it's 28. I'm sorry. I apologize. It's 280.164.
Okay. Thank you.
Point A. Sorry. The next, and also remember that the construction of the wireless communication facility within those designated zones is a by right use as an accessory use in those zoning.
Okay, why are we making it a by right? Well, I would think that you would want to at least have that be required to be reviewed by like the design review board or somebody else.
Well, that will, it's still, and there is a review process. That review will be conducted by the Citizens Communications Council, but there is a review process which we'll touch on a bit later in the presentation. So it's not simply it's not simply file for the permit and start construction. It's file the application, go through the designated review process, and then, if approved ultimately by the Board of Commissioners, they can go forward and construct that facility.
But when I looked at this before, it didn't seem as though the design review board was a part of that process.
Well, design review was part of the process, not necessarily in this section particularly, but in general, design review was to consider applications. One of our other charges was to clarify and codify procedures, because frankly, it was not always as transparent as some might like as to what the prescribed procedure was to file an application and have a wireless communications facility constructed. So one of the other things that we talked about in September, and I will touch on just a few minutes, is the procedure that we discussed in September and have streamlined even further. And there have been intervening regulatory actions which cause us to streamline even further the review process, which we'll also touch on in a bit. There's been a very important FCC pronouncement since the time of our September meeting, which really puts the township under the gun in terms of the timing within which these reviews have to take place. So it is subject to review. It's a review by the Citizens Communications Council, but we'll talk a little bit more about that when we get to that section.
Just one question. So
yes.
Is the December 3rd John Rice comments incorporating your latest document? Or
yes. Yes. As Mark pointed out, what we have included here is all of the comments that we've received to date that we've, they were not perfect fits with one another. Our communications council had issues that Mr. Rice might not have had, but they coming at it from slightly different vantage points. But in my conversation with Mr. Rice last week, really the goal here is to incorporate all of his comments, accommodate the FCC council comments where possible, since this is the area that his expertise really pertains to, and then move forward with a process that I think everyone can get comfortable with. Moving on, Section 280.164B. These are wireless communications facilities with support structures. These are towers. Support structures under the code are facilities that are constructed exclusively with the intention of supporting wireless communication facilities. So the tower at Radnor Valley, if you will, or the tower right behind this building are the types of facilities we're talking about in this section. The proposal here is to again have in the designated zoning classifications, which are just three, have these uses as accessory uses with a slight change where there happen to be residential uses in any of those classifications. And I'm not certain how prevalent that is, but if there are residential uses within those classifications, wireless communications facilities with support structures would not be permitted as accessory uses. But in any event, all of the applications for these sorts of facilities will be reviewed by zoning hearing and permitted where they make a determination that special exception is warranted. I guess the only exclusion from that is on property that is owned or leased by the township. This sort of a use, a wireless communications facility with a support structure, will be permitted by right and without the need to go to zoning hearing on property that's owned or leased by the township. it's a fairly narrow exclusion from the general rule, but it was one particularly, I believe, if you take a look at Mr. Rice's comments that Mark alluded to, that's one change that he,
Number 3 in Mr. Rice's letter.
Number 3, thanks.
Yeah.
That's one that he particularly wanted to see included, to give the township whatever flexibility it considered necessary. Now, there's obviously another public process by which the township would need to take action if it ever determined to construct one of these or permit one of these to be constructed on township-owned or leased property. But it will not be through the zoning hearing board avenue.
If, say the township owned, leased a piece of property for 10 years and arranged to have one of these constructed, let's say on the 8th year, once the lease expires, the person already has it there, is that correct? Or they wouldn't be required to remove it?
I believe that is correct.
And you're going to do that by right, on the leased property?
And there's a procedure by which they would make that determination, and comments of that sort might well be brought up. But yes.
I have a quick question.
Sure.
The part of this where it says, in no case shall a WCF with a support structure be located within 200 feet of any adjacent residential zoning, the township is also subject to that, even though they have the by right that they don't need the zoning hearing board?
I believe, I don't understand there to be an exclusion from that requirement.
Okay.
So they would be.
I mean, we have a lot of public land use that is frankly within residential districts.
Right.
So what are we saying? They have to be 200 feet away from the nearest residential structure? Because property itself is throughout the township.
Right. There's no exception for the other requirements of that section.
Okay.
So
Okay.
other than having to go through a special exception before zoning hearing,
Right.
it should be subject to that.
Okay, thank you.
Question. The purpose of excluding this from this section is just, what was the reason for that?
Meaning the township exclusion?
Yeah.
As I understood Mr. Rice's comment, it simply gives the township additional flexibility that it would not otherwise have. But again, there would be another public process by which the decision to construct one of these facilities would have to go through. But it was, I believe the intent of the comment was to not have to have the township go before zoning hearing.
Just to consolidate the process, in other words.
I mean, I think the opportunity for going through the same exercise twice was there.
Okay.
It eliminates the redundancy.
Yeah.
Okay. Okay. Here's the really one of the more significant changes. We can talk about what is referred to as the FCC's recent shot clock ruling, which basically says when a township receives an application for the construction of a communications facility, it has there are 2 time periods depending on the type of construction that's proposed. If it's a co-location, which is the construction of a facility at a site that already exists. There's a tower in existence, and another carrier wants to put another antenna on that structure. The township will have a 90-day.
Excuse me, John, just let me jump in really
Sure.
quick. On the package that you all received, the December 3rd, 2009 Rice letter, if you go through it, it's front and back, but the third actual page has a memorandum from Mr. Rice that addresses the shot clock ruling that was the declaratory ruling issued by the Federal Communications Commission dated November 18, 2009, which addresses these timeframes.
Right.
So if you want to glance at that really quickly.
And in essence, the township has always been required to make a determination on the siting of these facilities within a reasonable period of time. Reasonable minds differ as to what a reasonable period of time was, and some municipalities perhaps took longer than others in making decisions with respect to applications for these types of facilities. So what the wireless industry did was petition the FCC for a ruling that presumptively says here are time periods that if you go beyond, you are presumed to have not acted in a reasonable time period. 90 days for co-locations, 150 days for new applications, which the deadlines are what they are, but in a process where you don't necessarily have streamlined review and the opportunity for the clock to keep running was present structurally, the concern was that we needed to streamline the review process as much as we could. One of the areas where we have made the determination or the proposal to streamline that process is to remove the requirement that is present in the current code for design review board review of applications for wireless communications facilities. The provisions that are in the current code that still require these facilities to not have an overly egregious visual impact, for them to be designed with a view towards blending into the surrounding environment, whether they be affixed or freestanding constructions. All of those requirements which try to lessen to the greatest extent possible the visual impact of these facilities is still in the code. But that will be a determination that either the Citizens Communications Council or the Design Review Board will have to deal with when the application is reviewed. The concern, and I think it's a fair concern, is that an applicant might have to come to the Citizens Communications Council, go to design review, perhaps go to zoning hearing, and then hopefully get that review completed within the prescribed time periods, is really a risk that I don't think that the township should be put into the position of having to take. The effect of not meeting the shot clock is that a carrier may go to is it court or is it the FCC person? Go to federal court and say Radnor Township hasn't acted within the 90-day shot. They won't call it a shot clock. The 90-day deadline or the 150-day deadline, and they are presumptively unreasonable in the amount of time that they're taking to review the application, and the township could then be subject to sanction by the district court for having failed to act in a reasonable time.
So in order to streamline the process, the thought then would be to have the application go directly to the CCC,
right,
and ask them to act as both the CCC and the Design Review Board, rather than
right.
going to the Design Review. Are there designers on the CCC? Are there architects or landscape architects?
I don't have a full listing of the qualifications, but
because it seems like the Citizens Council for Communications, that wouldn't be a requirement that you be an architect or a landscape architect or a designer of any kind. So my question is, how's that going to work?
That's a fair question.
I mean, should we make sure there are designers on the CCC if we go forward with this system, or is that something that has already been considered? Or
yeah, I think it will be a consideration going forward. I would also, I think the current members of the CCC are mindful of the visual impact of the existing facilities and what these facilities should, in the best of all possible lights, look like. Unfortunately, these are not the most visually attractive pieces of equipment, regardless of how successfully or unsuccessfully design review has been able to nudge the applicant along in terms of lessening the visual impact. But it is something that we have seen applicants point out to us that have come before us, that we review photo simulations of the proposed use as installed. They are, applicants are more or less sensitized to the need to lessen the visual impact of these facilities. But, I can't stand here right now and say that we've got landscape architects or general architects or any sort of designers currently on the board. But certainly that can well be a consideration going forward.
Well, but you see, the point here is that, and she makes the point correctly, I mean, I'm an engineer. I like buildings that look nice and so forth, but I'm more concerned about the technical side of stuff. And you put an ugly antenna up there, it's not going to bother me as much as it's going to bother somebody from the architectural field, somebody who's from the design review board. Now, I would not have a problem with this if the application, when you're doing wireless applications, you actually had a meeting of both those boards together, so they'd have to discuss them in that way, so that you get them all in one shot. But I think that taking the design review board out is opening the door to a great deal of the possibility of coming up with some truly ugly applications and so forth. Mm-hmm. I think that this is, and
I understand your point. Part of it is there's certainly a presumption here that the current members of the CCC are able to differentiate ugly from nuanced and attractive. I think as a practical matter, there's only so much lipstick you can put on these pigs. But I am sensitive to the fact, and frankly, I live not more than 500 yards from a dormitory at Villanova University that has wireless communications affixed to it, and I see them all the time. And they don't look, yeah, they're antennas, but they're not in-your-face antennas, to coin a technical phrase. But, part of it is I think you need to rely on the CCC's ability to determine what looks good, what doesn't look good. Some of it's subjective. Quite frankly, you see facilities all throughout the township, and some are head scratchers, and some are constructed nicely and blend in with their surroundings. But the concern is we do not want to blow these new time periods, and
John,
this is a policy choice here.
There's a proposed addition to the ordinance that would permit the township to refer applications to outside consultants, right, which would be paid for by the applicant. Right. Would it be possible to add a provision here that, to the effect that the council or the township could refer applicants to the design review board for input?
Certainly, and
without
I'm sorry, John.
Without falling into the quicksand of getting into a time problem with the design review board's consideration of the matter. But would there be any problem with a provision here that suggested or required that applications be referred simultaneously on a parallel track with the design review board, or permitted you to get input for the design review board?
Yeah, John, I think that we can certainly would not have a problem with including language that would mention the availability of advisory help, help from design review. The concern with requirement, however, is one of timing and the various schedules that our boards meet on, and making sure that we're not putting ourselves in a spot where the process just gets so attenuated that we can't meet the shot clock. But an encouragement where warranted to ask for advice from design review would certainly, I think, be something that we can add without difficulty. Bruce, I'm sorry.
Let me just add one thing. In virtually every case, in every case of siting of one of these wireless communication facilities, there are two opportunities, one before the CCC, and then generally one before either the zoning board or the Board of Commissioners. Two opportunities for public input. Each of those hearings has to be advertised, or has to be on an agenda which is pre-prepared, so that not only the design review board, but any other interested architect or person who wished to comment on the design could come before those two boards and make their points. The problem is if we require input from the design review board, which requires another proceeding with another agenda, then we run into, in the case of a co-location, really serious 90-day problems, because you've got 3 agendas and 3 public opportunities. And I think you run into serious timing problems, and the real danger of the timing problem is the township loses all of its control over this process. So that's why we recommended that the design review board, a review by the design review board, not be required. Thanks.
No, thank you, Bruce. And and John, I believe the section you were referring to was section 171, and we'll talk a bit further about that section in a minute, because added in that section is a notice requirement that heretofore had only applied to applications that were heading for design, or for, excuse me, zoning hearing. But we'll get, hold that thought, and we'll return to it when we get to that section.
I'd like to make one quick question or comment here. Looking at the summary of the ruling that was made by, was it Tim Lay? That they also sent us?
Yes, Tim Lay is our communications counsel in Washington.
But he indicated that this is highly subject to challenge, and there's a reasonable probability that it would be overturned, because part of what they base this on flatly contradicts in what he says in terms of the inability through the local prohibition thing. I mean, he says that in many ways the FCC's ruling has it doesn't stand on anything in that particular regard.
But it is a ruling of the FCC today, and until it is challenged and overturned, the township has to comply with it.
I would agree with John on that one, Doug, just because I don't want, in my personal opinion, I wouldn't want the township being the ones to follow the challenge through the court system. I mean, the FCC has made a ruling that it's 90 days. I'd hate to see Radnor Township versus, or whatever, AT&T versus Radnor Township being the first Supreme Court ruling to challenge this FCC. It costs us a lot of money to get there. So, I mean, for right now, we really have to abide by the 90 days. And I know, yes, it's definitely, so I looked at it and 90 days, and there really isn't a ruling. Is it deemed approved, or is it, they really didn't say it, but they're saying 90 days. And I think we need to really focus on, okay, how do we get our process done within that 90 days? Whether, 6 months from now, finally someone challenges it and, yeah, they view it that it's a 6-month, sure, then we can throw every review board that we have in our township at it. But for right now, we really have to focus on how to get it down to that 90 days and what is the best process to get it into that 90 days, I think.
Yeah. But I did take comfort in Tim Lay's thoughts about whether it will ultimately withstand challenge. But I don't think we have the budget to fight that battle this year. Section 28164E. These are wireless communications facilities that are constructed within the right of way. I'm sorry. I'm jumping ahead. 164E was a section that created some confusion when last we looked at it. The concern was that in some way or another this section provided applicants a workaround for towers that would not otherwise be citable in any of the designated zoning classifications. And really, looking at the substance of the language, this was an instance where the heading of the section led the reader in a wrong direction. And basically what we've done here is to try to make clear by renaming this section that when an applicant comes in with a proposal to build a new tower, there has to be a showing that there is a need for a new tower. And the listed items that are in 164E are pieces of evidence that they can enter or offer to us, or in this case it's going to be the zoning hearing board, but offer to the zoning hearing board in support of their contention that there is a need for a new tower. One of the goals of the code itself is to encourage co-location. Namely, if someone builds a facility, other carriers are encouraged to use that same facility where technically technically feasible and economically feasible for their businesses, instead of running off and doing their own construction for a similar service. So really the concern was that perhaps the heading of this section was leading folks to faulty conclusions. And as such, we just renamed it to try to make clear that we're talking about applicants showing a need for a new tower as opposed to, you know, a blank check or a wild card that they can come in and play for a tower anywhere, anytime. 280.165A, moving on, is the section. Sure.
One of the things that I remember very specifically bringing up when we went to this over September was, it says costs exceeding new construction for a support structure are presumed to be unreasonable. I remember explicitly making the comment that that's not necessarily going to be true. We could, as a township, consider that even if it's more expensive than new construction, because of the benefit to the township of having only one tower versus two or versus three, that would be, why did you choose not to modify that?
Bruce, I'd jump in if you'd like to, but I think it is on its face unreasonable when we're talking about a co-location, because the difference in prices to do a co-location versus do a new construction are so vastly different that on its face, if someone was, you know, with benefit of mask or not, trying to hold up another applicant saying, you've got to pay me more than the cost to build a new tower just to co-locate, because that section is talking only about proposed co-locations and saying it's going to cost you more to co-locate than to build a new tower. That, I think, on its face is unreasonable, and it was our sense on its face that it was unreasonable.
But the effect of not, you know, the effect of leaving it this way is going to mean that you may end up with 2, 3, 4 towers on the same basic site or in the immediate vicinity of each other when only one would be necessary, even if it's going to cost the applicant more. I'm looking more from the township's perspective, not the service carriers.
I understand. I think I understand that point. I think generally, though, you know, these market participants are fairly reasonable, and there's only so much expense they're willing to go to construct their facilities. And if there are, say we get into a situation where there's a game of chicken and the co-location is more than a new construction and the applicant does not want to get held up. So they say, we need a new tower because these people have a tower and they're charging us more to co-locate. And they go ahead and build their new tower. Now you have 2. You're suggesting now that a third applicant will come in, play 2 games of chicken with the 2 cell tower owners, not be able to strike an economically reasonable deal with either one of them, and then commence construction on a third tower and get that through zoning hearing. I would suggest that, and I understand the need to certainly protect the township's interests, but I think in some respects the township will be the benefit of reasonable actors in the marketplace, not going off and spending what it costs to build a new tower just because they couldn't strike some kind of a deal with two people that have a possibility for co-location.
It's the idea that it's presumed. That's the thing that I find difficult, but all right.
Can I just follow up with one thing about that?
Sure.
The memo from John Rice that says the basis for denial, you intimated a moment ago that the zoning hearing board, in the event of a co-location and a second and a third, that they would all be subject to the zoning hearing board, except that this memo from John specifically states that the FCC ruled that you can't deny an applicant simply because there's other towers in the area. So to Doug's point, we actually could have that happen. I mean, I hear Doug's point about, and I do understand yours about cost, but the way I read this basis for denial, we actually could find our hands tied, the township, and have to have multiple towers in an area for that reason.
I think on this one you have to look at the entire section E, and the provision that we're talking about is the type of evidence which an applicant may submit in support of his demonstration that there is no existing support structure or alternative technology or building or other structure which exists to meet the needs of the applicant. And these 8 items that are then listed in this section enumerate the type of evidence which an applicant could bring forward to say that, and to demonstrate that he has a legitimate need to construct a new tower. It doesn't require us to approve it if he comes in and says, this fellow over here is charging me more than it would cost me to build a new tower. That's evidence, but it doesn't require us to approve a new tower in that case.
Is there any provision in this ordinance, I don't remember, providing a distance between structures? A physical distance between one tower and another tower?
Not that I know of.
All that goes to the technical need for a new tower. And the problem is that under the federal law, if there is a legitimate technical need for a new tower, in order that wireless service can be provided, we don't have a whole lot of discretion in those circumstances. And what we have tried to do in these proposed provisions is to say what an applicant must demonstrate in order to show that he has a legitimate technical need. And one of the things that would show that he does not have a legitimate technical need is there are 3 towers upon which he could co-locate. And the whole thrust of this, of these provisions, is to require people to co-locate rather than to construct new.
Bruce, would it add teeth to that section if where you put evidence submitted may consist of the following, where would you consider putting evidence submitted shall consist of the following, where you really make the applicant, as a lawyer, I always hate to use the word may because then I always fall, well, I don't have to. You only said I may do it.
Right.
Shall, you have to provide.
What he is trying to do here is to demonstrate that he has no reasonable alternative.
Okay.
And we are saying, these are the kind of evidence, this is the kind of evidence which you may bring forward to show that you have no reasonable alternative. And it's up to the reviewing bodies, the CCC and the zoning board or the Board of Commissioners, to make the determination, the ultimate determination, as to whether he has a reasonable alternative.
What you're saying is that the burden is always on the applicant.
Sure.
And in presenting its case, it may present evidence, and you will listen to evidence if it's presented.
Exactly.
It falls into one of these categories.
Exactly.
Okay, Section 280-165 relates to wireless communications facilities that are constructed within the public right-of-way. And in an effort to clarify some points that are in that section and address other comments that we've received, we have included express language that use is by right after a review by the CCC and approval by the township, meaning the Board of Commissioners. We have added a height limitation for these facilities within the right-of-way to 60 feet. To my recollection, we have only seen one applicant come in at a height higher than 60 feet. And the number is intended to strike a balance. Certainly 60 is more than the height of your typical telephone pole. That is beyond argument. But previously there was no limit. And we think 60 strikes a balance. And we, based on what we have seen from other applicants, that limitation would have accommodated all but one applicant. So we're trying not to be exclusionary, but we are also trying to put a reasonable limit on the height of these facilities. And there's one application that we've seen that was well in excess of that, and there was a sense that a limit was needed.
John, is this section attempting to address the location of wireless transmitters on poles primarily? And is the right-of-way you're referring to here the utility right-of-way primarily?
Yeah, right-of-way is a defined term, John, but yes, generally speaking, that's right. That to the extent that the township has granted rights in the right-of-way previously, or wishes to do so in the future, that these facilities will be affixed to typically telephone poles.
Well, I'm a little confused because the definition of right-of-way refers to the street type of right-of-way.
That's right.
Rather than, and perhaps right-of-way is the wrong term, an easement.
No, these are rights-of-way, John.
Okay. Well, let's talk about the area where a line of poles, utility poles exist. And let's assume it's out of the street right-of-way. Right. They exist by virtue of an easement, and let's say in the backyard. Mm-hmm. All right. And the wireless provider wants to put a device on one of those poles. How is that application affected by the ordinance generally and by these changes in particular?
That's an application that would be subject to review under Section 280.164A. That is an attached wireless communication facility, namely a facility that is looking to be attached to an existing structure that is not within the right-of-way. So if I've got a Pico pole in my backyard, and I'm saying, well, cell coverage is awful here. Let's see what we can do. I would have to submit my application and go through the process that's lined up, that's prescribed in 280.164A. The first point that should be made there is that under 164A, those facilities can only be attached to structures that are at least 60 feet high. So if there's a concern that there will be a proliferation of, these facilities in backyards affixed to poles that are subject to private easement, 164A makes clear and also prescribes the zoning classifications within which they would be permitted. But it's a 164A application.
I wanted to hold this possible digression until later, but I think this is a good entry point to talk about it. I perceive as one of the problems of wireless communication now to be twofold, now that wireless communication is so prevalent. In addition to the historical concern about ugly towers all over the place, there are areas of this township where wireless service is awful. where residents go to out in the street, sit in their cars, go to the end of their driveway in order to take a simple cell phone call. And it seems to me that as a general matter, the Board of Commissioners would be concerned about that because of the prevalence of wireless communication. So my general question is, what is the council doing to address that concern where it may not be in the immediate interest of the provider to provide any better service than its competition? And secondly, to provide, to let the providers know that if they want to build towers or consider, I don't want to use the term consideration, but there's an expectation that if they're going to provide wireless service in an area, it's going to be good wireless service, and it's going to meet conventional standards, which today involves a lot more wireless communication and a lot more cell phones than existed just 10 years ago. And thirdly, if there are means to address these gaps in service or the poor service, and some of those means involve putting smaller devices on more structures closer to homes, can that be done in an unobtrusive way, and how does this ordinance address it?
There are many questions there, John. Let me try to take.
There were three major ones.
If I can interject, just one.
Mr. Chairman, I don't want to digress, but I
yeah,
do
but John,
think this is relevant.
Let's just keep it pertinent to, I think the third question is really the only pertinent question relating to this ordinance. What the CCC is doing with regard to
well, fair enough. Fair enough.
With wireless, I understand this township does have cell zones that die out, and that's something that the CCC from us is, if you can in future look into that. But I don't think it's really fair.
Well, I'd like to return to that at the moment, but
but I'd like to just,
I'll concur that the third question I think is very relevant. I'd submit is relevant to the ordinance.
I believe he was questioning the ability for when the smaller, or if there's smaller devices for the wireless carriers to be put onto poles closer to homes or residences that allow for further. How is that addressed in this ordinance?
Okay. Quickly, the goal, one of the goals of the code is to encourage the proliferation of these technologies throughout the township. We can't prescribe coverage, but we can try to accommodate wherever possible carriers that want to come in and improve their service. It is a very market-driven task, really. If there's spotty coverage, this code cannot go to T-Mobile or AT&T or Verizon and say, you've got a dead spot in northern Radnor Township. What are you going to do about it? We don't have that. We don't have that ability. And I don't know that other than permitting or creating a scenario where they can go in and build their communications facilities, there's nothing that this code specifically does to incent or provide some sort of benefit to carriers for providing coverage in spotty areas. That said, certainly we have seen more applications recently for facilities in the public right-of-way because carriers driven by market forces are saying we've got to start filling the gaps. And in looking at what this code does with respect to allowing those facilities to be constructed in rights of way, we did not want to be exclusionary in any way. So, we make clear it's by right if you go through the application process and review process and are approved by the township. We've put, I think, a reasonable height limit in to say, okay, you don't have to stick your facility on a 24-foot pole. If there's some way, perhaps, that you can find a 50-foot pole, you can put your facility on that. So we are trying, the code is designed to give carriers the opportunity to make their business decisions as to how they want to respond to the market and respond to the market's reasonable expectation that there be good service. But we can't require them to do it, and we do have to strike balances between having facilities everywhere and having some sections of the township where you're not going to see as many of these towers.
John, is there going to be an incentive for the carriers to replace 24-foot poles in their easement areas with 50-foot poles by virtue of anything that's being done?
Well, this says a minimum of 60.
Well,
Pole has to be 60
164A
feet.
applications have to be affixed. That's a 164A application if you're talking about a private easement. And those facilities have to be affixed to something a minimum of 60 feet high. The right of way, the public right of way, if you will, as opposed to the easement sort of use, is limited to 60 feet.
John, under what circumstances can someone take 24-foot telephone pole out on the front of anybody's street and increase it to 50 feet or 55 feet? Is that okay?
They need to have some sort of an agreement with the owner of that pole to begin with, and we've seen applications.
No, but I meant that's in our control. They're allowed to do it in our control. I mean, we've given them permission to do that in essence?
I believe we have, yeah.
Excuse me, John. 165A seems to say existing right-of-way structures. So to change a 24-foot pole would be a new structure, wouldn't it?
I think it says other existing right-of-way structures, right? So utility poles, light poles, mast arms, or other existing right-of-way structures.
So to replace a 24-foot pole with a 50-foot pole would be a new structure, perhaps?
Or
a new pole.
What if you put an addition onto it?
You could put a 10-foot extension with an antenna array on the top of say a 25-foot power pole, for example.
I mean, my biggest...
That's what we would like to see, that kind of stuff, rather than
80 foot.
Or even 60.
But I guess the question, my biggest concern is as the technology, because right now I think below 60 is not technically feasible for them, and they like higher poles. But if the technology changes, are we giving them permission, in essence, I think we are, to put anything, add to telephone poles up 50 feet? And the question is, do we want them to have that ability? Because I would imagine 50-foot extensions every, eighth of a mile down Lancaster Avenue would be quite unsightly. And that's my concern. Today, it's not technically feasible, as I think I've understood your presentation. But I think the technology, there's a good chance it could change where it could be feasible and where you'd need them more frequently, so they'd be more of a nuisance and more of an eyesore in that scenario. And I would like to personally see some protection against that kind of a situation. I don't mind them on existing telephone poles, but to extend those and double the size of them, I'm really thinking of that thing in front of the old bowling lanes in Devon where they took that telephone pole and extended it. And I kind of think that's pretty unsightly, and to have that every eighth of a mile on our public roads, to me, would be pretty unsightly.
Well, don't forget, each carrier could do that. It wouldn't necessarily be one carrier doing it every 8th mile. It could be 4 different carriers doing it.
Yeah, so you could have one on every pole, in essence. Yeah.
I have a similar concern, but I'm concerned about unintended consequences if the technology changes. So you have a line of poles in or outside the right-of-way in a neighborhood, in a street, and the technology exists to put one booster per 1,000 feet or 1,500 feet. And the question is, and so they come to the township and they say, we can put this booster on a 40-foot pole, 50-foot pole that now exists to boost the service to everybody within 1,500 feet of this pole on the street, which is 10 or 12 houses. Can we do it? And I'm concerned that the ordinance may be too tightly drafted so that the answer is no. And so the benefit that's sought to be obtained, it can't be because of the unintended consequence of the way the ordinance is written.
it might be useful to consider what would happen under the existing code in that sort of a circumstance.
Well, what would happen?
Well, there are no height limits in the right-of-way, and
but they wouldn't be able to do that as of right, would they? But in any event, John,
frankly, I think the way the code is construed currently, yes, we're just making that
but
more
if
explicit.
we're taking if we have an opportunity now when we're amending the statute to address a potential unintended consequence, it might be good to consider that. I don't have a specific suggestion, but I'm afraid if you prohibit these booster devices, if such things exist, on only tall structures, you may induce the carriers to find ways to propose tall structures or not provide the boosters. And it seems to me that we ought to be able to have a review of a booster under the normal review for appearance and that sort of thing, and permit it on an existing pole. I would suspect these devices are no bigger than a transformer. So, we're used to seeing transformers on poles. If there can be a box put on a pole that enhances the service to a street, so you put 2 or 3 in a neighborhood and you've solved the problem and effectively obtain the effect you would have by having a new 60-foot pole down half a mile away, I think that's a desirous result. And I'd hate to see this ordinance have the unintended effect of discouraging that sort of use of technology.
But Johnny, are you talking about putting on an existing pole, or are you talking about extending the pole?
If the technology exists to put an unobtrusive device on an existing pole, I'd hate to see a circumstance exist in which the ordinance discouraged that because it was attempting to limit, it had other good intentions, but it had the unintended consequence of discouraging the use of unobtrusive devices on existing poles.
What my concern is not existing poles. I mean, we're stuck with existing poles.
I understand that. That's why I spoke up, I think.
Yeah, mine is extending, raising the height of existing poles.
I think you have a valid point as well, but I think it's different than the one I'm raising.
Yeah.
And here is exactly the tension between trying to strike a balance between the technologies that exist and we're familiar with or can reasonably foresee today and what might be down the road 2 or 3 or 4 or 5 years from now. What we're trying to do here is to strike a balance predominated on the presumption of what we've been seeing and where we perceive the trends to be going in the applications that we've received. My position would be if a new and less obtrusive technology does appear, we shouldn't stand in the way of that. But we're trying to do a number of juggle a number of balls simultaneously, and where we came out based on what we know of today and where we see the trends going, really is the balance that, or the amendments that you have before you this evening.
All right, from a technical perspective, as the number of cell phones and wireless devices increases, in fact, the sizes of the cells are having to get smaller. The distance that they're able to see, it's actually more desirable from a long-term perspective to have smaller towers that cover smaller areas, but to have a larger proliferation of them. Is this ordinance going to facilitate that, or is it going to stand in the way of that?
I mean, I frankly think that it does. It certainly, in uses that are feasible from the height 60 feet down, users will gravitate towards placement of those facilities within the right-of-way. If that technology doesn't present itself, or for some reason or another the technology makes sense to be higher than the 164A type application, structures, facilities that are affixed to existing structures at a higher a greater height would be presumably the way they'd go in that instance.
I'm actually looking, I personally think that this 60-foot height is too high. I think that it should be reduced to like 40 or 45. There would be more of these base stations, if you will. But you wouldn't have towers that are, 60 feet is fairly tall.
I would agree with Doug. I mean, you know, you think about a building or even a home in Radnor Township, 36 foot at the eave. That's a tall structure, 60 feet. And I think one of the things that we're not considering is that there are areas of the township that have elevation where others don't. So as an example, if you're coming up Conestoga Road going into Garrett Hill, there's a barren hill there that would be perfect for a high tower. Maybe that's a suitable place to put it. But 60 feet behind a high elevation like Wayne Presbyterian Church may not be an ideal height. So I think we have, you know, not to be overcomplicated here, but we do have to give some thought to where they're being sited and what the elevation is in relationship to the rest of the surrounding, you know.
Yeah, and Matt, the other part of what we've dealt with in the existing applications that we've seen is a lot of the applications come in at between 40 and 60 feet. And that seems to be what the carriers consider to be a sweet spot. I'm certainly mindful of the point, and the concern I would have, and you know, as far as I'm concerned, 60 is not in stone. But the concern that I might have is, as we ratchet it down, you know, when ultimately, you know, carriers weigh in on this proposal, and they've not yet done so, but I expect that they will. One of their points of contention will be technically, you know, a 45-foot limit. I'm just pulling a number. A 45-foot limit, it doesn't do what we need it to do, or does it halfway, so we'll need two instead of one. Right. You can project what the arguments are going to be, but
yeah. I think that would be an important thing to understand as it relates to the technology, because I can't get the vision that Steve was talking about out of my head. As you go past the Devon Lanes and you have a single-story structure with a pole that stands out like a sore thumb, that seems to me accommodating an elevation. It's not necessarily there for a well, it certainly does. It's not consistent with the surrounding building.
John, what would the possibility be, as 164A now does, in addition to requiring that the structure be on a pole, essentially, that's 60 feet high, it also attempts to draw a correlation, I think, between the size of that structure and the additional appurtenance that's being added to it.
Proportionality, if you will.
Right. Proportionality. Perhaps the proportionality concept could be expanded. And so if Doug is correct that there will be a development of smaller cells, that smaller cell be proportionate to the structure in which it's put. So that, getting back to my example, if you have an existing 45-foot pole in a neighborhood or in a right-of-way or outside a right-of-way that has existing electrical devices on it, including a transformer, which is about 6 feet high, I would guess, or 5 feet high. And it is proposed to put a cell there which is not disproportional to what is already there. It seems to me that you could view that differently than a device that would be 3 times the size of the transformer. And I think the same thing would apply in the downtown Wayne, for example. If you want a small, discrete item on an existing building, that's one issue. If you want a huge device that's going to stand out and be noticeable to everybody, whether or not it's high, that would be another consideration. So perhaps proportionality and to use a non-technical term, the way it blended in or was consistent with the structure on which it is placed might be an approach.
Or if we could just limit it to existing structures. I mean, if there's an existing telephone pole and it's 45 feet, then, or 60 feet, then so be it. But if it's 24 feet, then it's 24 feet. You just can't keep on extending these things to put, towers on top.
Yeah.
And to that point, who controls the height of the existing power poles? That's under statute or code? I mean, what if a carrier goes to PECO and said, you know, if you could replace these 20 poles with 50-foot poles, we'd pay you 50 grand a year for these cells?
And we've seen applications where part of the application is to replace an existing pole with a higher pole. So, I mean, they're not going out of pocket in advance. They want to get the approval and then do it. So, I mean, that's certainly foreseeable, that carriers who have agreements with current right-of-way users to construct what they need or they perceive that they need before making the application. I mean, I don't know that there's anything that we can do that would throw a roadblock in that. I mean, that's...
Sometimes the owner of the pole may be the wireless provider
or
a related company.
It could well be.
How's it work now, Dan? Who controls the height of the pole?
The owner of the pole.
Right.
They'll come in and get a permit from the township to replace a pole. Typically, we have not paid attention to the height because it has not been an issue until recently. And they'll come in and say, we're replacing the poles on this street because they're 40 years old and their life expectancy is gone.
And what's the typical height of a pole in a neighborhood?
35 feet in a neighborhood.
45?
35.
35. Well, you'd hate to be hearing, Dan, someday that all the new poles are 60 because your wireless ordinance.
No, I mean, we were talking about Devon, the Devon bowling lanes, but if you look at 252 near Goshen Road, they replaced all those poles to feed power to Episcopal. They are big poles. I mean, I think I heard they're 80 feet tall, and they look every bit of 80 feet. And every one of them, not just the one at Devon, it's like 10 or 15 in a row. They stand out.
Listening to this discussion, I think maybe it's wise to step back and look at what this ordinance tries to do. Starting with the proposition that we don't have, under federal law, the ability to deny a carrier the right to provide effective wireless service. We don't have the right to require him to do that. But if he comes and asks for it, we can't tell him no. So I guess we've all heard the word nudge a lot lately, at least out of Washington. This ordinance, I think, does more than try to nudge applicants toward what we'd like to see them do. It says, well, if you can co-locate, we're going to shove you toward co-location, toward existing towers, toward existing facilities on existing buildings. That's 260, 280, 164A. And we're going to shove you, in the case of smaller things, toward the public right-of-way, where there are already poles, wires, transformers, things that impede upon our vision. So we're going to ask you to go where you can. Don't build anything new. And in the case of smaller facilities, go toward the public right-of-way. And if you think of this ordinance in those terms, that what we're trying to do is shove applicants toward desirable locations and desirable facilities, that's what we're trying to do here. Nobody is going to come along and say, I want to put this great big pole in this valley, because it doesn't make any technological sense. They're going to look to where their signal, what's the word, germinates? No.
Oh, no, I know. Keep going.
Germinates, I think,
Yeah, okay.
is the technical word. They're going to look at where this signal can cover the most territory effectively. And I'm certainly sympathetic to the people that say there are places in this township where the signals are awful. Because with one carrier, I went out, I got a phone, I said, yep, you'll do fine there. I took it into my house, no service. I had to go out in the driveway. I took the phone back, and I went to another carrier. and this is how competition works. That carrier signal in my house works fine. And if the first carrier wants to cell service in my neighborhood, he's going to have to fix something. But we can't require him to do that. But what we're trying to do here is really shove these applications toward where we'd like them to go, both from a point of view of not proliferating ugly facilities in the township and at the same time providing effective service.
Well, that goes precisely to the point. I mean, I would much prefer to see, say, a 35-foot poles down the middle of, I live on Poplar Avenue, North Wayne, and every 5 or 6 of those have a small, 5-foot tall cell tower on top of that, and then have lots of little cells in there, rather than have a single tower, which might be 60 feet, 70 feet tall. I mean, both of them will work technically. The thing is that the one that has the shorter, the smaller thing on top of the telephone, you're going to have more of them, which is going to cost the company more. You're not denying them the ability to provide service, you're just making it more expensive for them. But at the same time, you're preserving the integrity of the community, at least the visual aspects of it. That's the piece that I'm looking towards.
I mean, that's what we tried to do in this ordinance, which is to shove those smaller facilities toward existing facilities in the right-of-way.
Okay.
Because that's the easiest way for them to do it.
Yes, but where the existing facilities outside the right-of-way, you've imposed a requirement that it be 60 feet tall. And it's the facilities outside the right-of-way that have the most contact with the residential areas.
But,
so
John, excuse me, remember that 164A applications only go into, I believe, one residential zoning classification, which is R5. So there's a different issue that has already been decided by minds greater than my own as to what residential districts we're going to permit these uses in. And the decision has been made R5. So...
But I think, John, that I hadn't thought of that, but I think that raises another point, and it may amplify, no pun intended, Doug's concern. If you have carriers desiring to provide better service to a neighborhood, and their choices are small devices on poles that are outside the right-of-way, because when that neighborhood was developed, the poles were put in the backyard, or not down the right-of-way, or build a new tower somewhere. We don't want to inadvertently push them in the direction of building a new tower, because somebody's not going to be happy with that tower. And
I understand that point, but I also I need to sort of go back to first steps here. We were not charged with rewriting the wireless communication facilities code for Radnor Township, and we took as decided some fairly basic and wide-ranging areas. One of which is that there's a very circumscribed list of zoning classifications where these uses are going to be permitted. Technology changes, and perhaps at some future date it might be appropriate to rethink the assumptions that have these facilities only in R5. Because it strikes me that the concern is towards sort of perhaps two areas of the township, mostly residential districts that have the drops in coverage. And then there are areas in the township where there's much more open space that perhaps have dead areas as well. You think of the Willows and other places where the coverage is spotty. Given the time that we had to commit to this process and some of the basic assumptions that we were working on when we started work, we've made our best determination that what is before you is appropriate for where we find ourselves in the marketplace today. But I mean, believe me, the world changes daily, and now I found out today that my iPhone is going to be obsolete when Google's new phone hits the market in a week or 2 weeks. So I feel like a dummy for having gotten one of these, and technology marches forward. We can anticipate it as much as we can try to, but we also weren't in a position to rewrite and rethink a lot of the code. Let me kind of skip forward. The other addition that interestingly was not a part of our prior code, but has been suggested to us, is to include a requirement in applications that where the right-of-way is on a state road or state road, that the applicants show that PennDOT has approved their use as well. So we have added that to the within the right-of-way section. Finally, section 280-171 adds what has been, I believe, a desire of a number of people to include a notification process for all applications, not simply applications that have to go through zoning hearing because of there having been applications for support structure type facilities. The notice provision that we've included is modeled very much after the zoning hearing board's notice requirements. So there's a geographic radius within which immediate residents near proposed WCFs need to be notified of the application. There's a general public notice, and the intention, of course, is that residents in the township and other affected people in the township know that these applications have been made, and give the public the opportunity to comment on these applications when they are reviewed by the Citizens Communications Council. And again, there was some thinking that might add an impermissible amount of time to the review process, because obviously the notice has to come when the application comes in, and then there's a period during which the notice is allowed to play itself out, and then we have to get to review. But the thinking was that the notice is a very reasonable trade-off so that the public knows that these applications are being submitted, because in some instances that has not always been the case. I'm happy to entertain any questions you might have.
I have a small question.
Sure.
I think it's in section 280-166. IJ. You have a provision to require that the WCFs not utilize the display of any advertising. I'm concerned about that and would like to see that bulked up, because is advertising a defined term?
No.
I don't want to be going down the street and seeing taller poles than we have now, even if they're less than 60 feet, and having it say Verizon Wireless on it, and have them say, that's not advertising, that's an identity. That's just to tell you this is our pole. We're not advertising anything. But I'm going to see Verizon Wireless every 20 feet, and then I'm going to see AT&T, and then I'm going to see. Is there a way to beef this up so that there's no signage that's not for safety's sake on a tower?
Caution.
Yeah, caution, this is the tower, climb. Go away. I would just like to see that sort of worded in a way to make it stronger.
You could add or the words or commercials.
Yeah.
Or signage, or I don't really know what the right word would be.
Or commercial sign, advertising or commercial signage.
Which would include
Certainly,
identification.
I'm worried if you put signage and somebody wants to put a danger sign on it, you want to be able to do that. So that's why I said commercial signage.
Yes. Okay. Mr. Chairman, I believe you mentioned you had a couple thoughts.
Up first. Does anyone else have any questions, concerns?
Yeah, just circling back to 165 one more time. I think we touched on lowering the height from 60 to another level. I think the reason that utility poles now generally in residential areas aren't that high is that maybe the trucks or the cranes servicing the lines can't reach much higher, but you could certainly see PECO installing higher poles to attract a carrier. If we fix it at the height of the device, I think that fixes all the problems about what poles go in or not. If we could lower that height, I think that would be a good thing, maybe to 50 feet or 45.
Yeah, 60 is not in stone, but
Well, do we have to do that here? Do we have to go back to Dan, wherever the existing ordinance is? Because obviously, that's not going to solve the problem.
The
I'm
zoning,
not
is that
aware
a
of any limitation in the existing ordinances.
Do we have to make a recommendation should go
zoning?
to zoning? Because
No,
obviously, this is nice, but if someone comes in ahead of time, he can raise the pole up first, and then he beats the ordinance that way. So we don't want to make it like a loophole.
Unless the device can't be installed higher than 45 feet or 50 feet.
Well, if the pole's already 50 feet. My point is, if Dan doesn't control, or if we don't control now the height of the poles, they can come in and move them all to 50, and then they've beaten the ordinance.
Well, that would be expensive, hugely expensive, because you have to do all the reconnection of the power and the phone lines too.
Yeah.
And cable. I mean,
Does
Can we
anybody have
accomplish-
any idea what the effect would be, given the size of poles that are there now, locations and the landscape that you all see on a regular basis at council? And you're talking about 164A?
165, I believe.
165.
165.
165A1.
A1, right. A1.
If we
Shall not
inserted,
exceed 60. Okay. Well, let me ask my question with respect to both 164A and 165A. If both of them said 45 feet, what would the practical effect of that be? Does anybody have a sense? Would it defeat your purpose? Would it cause a problem, Dan, in the?
Well, I mean, I don't know distances, but as the pole comes down, the area that it covers shrinks. And I
Right.
don't know if it's linear or algebraic, that as you
Right.
come down, it gets that much smaller.
But wouldn't we be better served, because we're still going to bump up, if we lower this to a point that is by industry standard considered too low, aren't we going to bump up against an unreasonable misprovision? Is that what I'm hearing? So aren't we better off covering this not in the cell phone ordinance, but in an addendum to the zoning ordinance to limit all the poles to existing heights or shorter? Could that be done? And
I like the idea, but I think we're going to run into the same thing, because PECO is a utility company that is governed by certain, they've got theirs, and unfortunately, most of the public utility companies, for lack of a better term, I can't think of the word, basically trump our zoning ordinances. Under the same thing, if PECO needs to run their power lines at 60 feet because the high power lines running overhead will, zap little kids as they're riding bikes, if they're lower, then they're it's
But
kind
that's
of the
their,
same thing.
but that would be a PUC issue, not a communication issue, right? I mean, they'd have to prove that they have a need for power, not to sell time to a wireless provider. So that would provide us a fair degree of protection.
But could, because we're talking about the wireless device itself, if we were to set the limit to 45 feet, yeah, they could trump it by throwing the 60-foot pole, but still the wireless provider is still capped at the 45 feet. So he's still, if we choose 45 feet, it's really where the wire, so if there's 15-foot of pole, and as I guess, I don't know who said it, but you're right, it's very expensive to change. I think Skip said it's extremely expensive for the township to, not the township, but the utility companies to change these poles with everything that's on them. So I think maybe the focus is for us to take a look at what height is our comfort level, and trying to take into account what Steve said. Obviously, we don't want to run into a problem where the FCC comes back and the unreasonable argument gets thrown in our face.
Well, you said most of the applications are coming between 40 and 60?
That's right.
So if we're picking 45, is that reasonable? What number would you say you're 60 isn't in concrete in your mind, what number would you suggest? Since obviously the board seems like it's leaning towards a lesser number. Can we get away with 45, and you can always come in and ask for,
Yeah, I think 50 is probably,
John,
Yeah.
how about giving you all some discretion to say that in your discretion, you can modify these limits for good cause shown? So that if you find that somebody makes an appealing case to put something below or above or below 60 feet, that's now, as I read these two, one of them requires a minimum of 60 and the other provides a maximum of 60.
that's right.
Okay, so if you don't fit into that square peg, but you've got an attractive round hole, or vice versa, why couldn't the council have the discretion for good cause shown, and upon receipt of the evidence that's outlined in that section we talked about, Bruce talked about, to make an exception, if it would serve the purposes of the township? Are you an adjudicatory or
No, we're
advisory?
not. We are an advisory board.
Well, I think that's a further argument to give you some flexibility to say to the commissioners, there's some room here to accommodate shifting needs and technology, and so we're not coming back and amending this ordinance. The problem with when you stop and think about a statute, if you start putting in specificity as to feet, anybody would tell you that you're taking a risk that when something changes and those feet aren't applicable anymore, you've got to run back and you've
Yeah, and
created too tight a noose.
Yeah, and I mean, obviously, we're obviously an advisory as opposed to an adjudicative body, and the ultimate decision on those items that we review will be made by the Board of Commissioners. So some of the issues that you get into when you provide a board discretion, and then start treating arguably similar applicants differently, perhaps goes away, since we're just passing on a recommendation. Ultimately, though, to the extent that ambiguity or the opportunity for driving those sort of wedge arguments that you're treating me differently than AT&T, why are you doing that? Ultimately, somebody is going to be not someone. Somebody will be subject to having to address that argument, and in our case, it's the Board of Commissioners. But I'm not opposed to.
One other thought, just I'm thinking through everything that's being said here. Remember, it's the zoning code. This is a portion of the zoning code, so therefore, if we set a 45-foot maximum, if that's the number we choose, if they want relief, they always have the avenue of getting a variance from the zoning board from the 45-foot limit. So, I mean, remember, this is a portion of the zoning code and is subject to to zoning code's jurisdiction.
And we'd have to be you're right, and so we'd have to be very careful that the discretion, you can't build discretion into the zoning code because that's the province of the zoning hearing board.
Exactly.
Yeah, no, Mark makes a good point, but it seems to me there's a solution to this issue somewhere.
John, I have a question for you. If we say 45 feet or 50 feet, whatever it is, but then if the technology changes and 60 feet is the way everybody's doing it today, we're still subject to restraint of trade, according to the FCC. Is that correct? I mean, we're limiting them because that's the way everybody does it now. So now we kind of have to toe the line, right?
Well, it's funny. It's funny that you raised that point because Bruce just handed me something. We have seen an application for an 82-foot pole for a 72-foot pole, and then poles well below those figures.
We presently have 4 pending applications in this township. One seeks, and this goes to the question of 60, which was kind of already a compromise.
Mm-hmm.
The one seeks to replace a 29-foot pole with an 82-foot pole. Second one seeks to replace a 24-foot pole with a 72-foot pole. The third one would just put antennas on existing poles, and the fourth one is for co-location on the tower outside the township building. The latter two probably don't cause anybody a problem.
Bruce, the first two, where are they? Are they right of way? Are
Whereas
they
the first two,
telephone
they're
poles?
both right-of-ways,
They're right of way, so they're telephone poles.
yes.
That's one big telephone pole.
How tall a pole can you have without, buttresses?
Depends how deep
Legs.
you put it in the ground.
So basically, this group, we just really can't limit them. If the industry standards change, we kind of have to toe the line. And
Well, if the industry standards change, don't forget, what you can't do
right.
is tell a guy he can't provide effective service. Now, what this ordinance is struggling with is to wrap some standards around that. Now, if the technology changes, if somebody comes up with this magic box that you can put on the ground, let's say.
Right.
It's a 6-inch box that you can put on the ground. It looks, or you can stick it on existing cable boxes or something like that. Then you change the ordinance. Because at that point, you have other ways to satisfy the requirement that you cannot deny effective service. And it becomes a lot easier.
Right. Or if we if we try to limit the poles to existing, then we're limiting the person they're going to go to try and cut a deal with.
They're going to come along and say, if I am going to serve the area down on Goshen Road, I can't do it off a 24-foot pole.
So they're still going to have a right to override the zoning.
And they go to, in that case, they go to the FCC and say, Radnor has denied me the right to provide effective service.
Because we've limited the height of the existing poles.
Yes.
If Radnor denies it.
If Radnor
But they can
denies
make
it.
that presentation. If we change this 60 to, let's say, John's suggestion to 50, and they come in and say, the only way to provide services, we need 55-foot poles, zoning board would have the right to give them a variance, and it wouldn't go down that path. So I like John's idea of going back with 50.
I like 45.
John's
Do I
done a
have
lot of work.
48? Do I have 48?
I like 45.
If John's picking 50, I'll go with him. These guys are the experts, certainly not us. I don't know.
It's the same number of keystrokes.
Let me say, we have the ability through our FCC council to check on what is an existing national standard. And suppose we do that, and he has the ability to go to technical people that can tell
Find
us
that out.
whether 45 is defensible, 50, 55, 60.
Yeah, and the.
Don't forget the minimum.
don't forget
That's the maximum.
And-
Don't forget the minimum.
The fact that we've got varying height applications now certainly argues that perhaps there's, not so much of a national standard as we might think there is. But also, I think in some respects, those applications came in at those heights because we also didn't have a limit. And because we've seen increasingly taller applications, which tells me that they're finding where the envelope breaks, and then the application will plateau at whatever level they can.
Well, we're certainly used to seeing that from other development projects in the township. But more importantly, what happens with the 80-foot application that's pending? Does it fall under this particular?
No, it'll be reviewed under the currently existing code.
Currently existing code. So, I would suggest that we come up with a height and we become precedent-setting tonight, because we don't want to see 80-foot poles in residential areas that have 36-foot roof lines. It's going to start to become pretty unsightly. I'm for 45 feet, by the way.
Thanks, Matt.
It's important to note that the higher the antenna is going to be, the greater the coverage area is going to be. So they're going to put that, if they could put a 200-foot pole up there and have one antenna that's going to cover 10 miles, they'd love it.
Absolutely. Yeah.
But
no.
we're supposed to be looking out for the.
I completely,
Right.
and again, you made the reference a couple times to, it's all about striking balances at this point, because we want to provide the service. We want to permit them to, fill in dead coverage areas where they exist. But, we don't want sequoias along Sproul Road. I mean, we just don't. So.
What's our goal tonight, Mark? It just have to be formally approved and passed on to the
It has to be
commissioners? or-
formally approved, passed on. I mean, I have some other comments that I can make in here. First, I was just going to ask, is there any public comment out there? I'll let you have your public comment.
I'm Sarah Pilling, and I live at 29 Garrett Avenue, and my property directly abuts Radnor House, still called Chetwynd in our neighborhood. And I have a row of telephone poles that are not in the right-of-way, but fortunately there are linden trees that are twice as tall, so they'll never put towers in those. I just want to thank you for putting the ability for the public to know what these applications are ahead of time, so there are no surprises, so that we can weigh in if we're being faced with a 60-foot pole with a 20-foot house, or I think almost as importantly for the public land use, that the possibility of cell towers going in our parks is really an issue for the township, and I think that the residents really needed to be notified, so I want to thank you for putting that portion into the ordinance. That's all.
Thank you, Sarah. I had one letter from Rick Barker. It was given to me at the December 8th. Did you get a copy of that?
No, I did not, Mark.
Okay. I'll just read it. Please excuse the lateness of this letter. I did want to share these viewpoints with you in writing because I am unable to attend the meeting this evening. I offered comments during the September 8th Planning Commission meeting concerning the proposed amendments to Article 28, Wireless Communication Systems, Section 280-161 through 280-171 specifically. 280-164A, he writes, strike out, quotation, or support structures, quotation, in both instances where they occur in Section 280-164A. Inclusion of this language makes both A and B confusing. The definition of support structure excludes, quotation, any device which is used to affix an attached wireless communication facility, ... end of quotation. And the definition of attached wireless communication facility includes, quotation, any device which attaches the antenna array to the existing building or structure, ... end of quotation. In my opinion, the language, quotation, or support structures, quotation, is unnecessary and implies or even invokes Section B, wireless communication with support structures, comma, and could be construed to permit a maximum height of 120 feet on any building in the permitted districts, clearly and unintended consequences. It seems to me the most straightforward fix would be to eliminate this language or support structures. It would not involve any changes to definitions. In addition, since the amendment to 280-164A constitutes a significant relaxation of the height limitation, I suggest that the inclusion of R5 in particular and C2 and C3 as well be reevaluated. All of these districts permit a maximum height of 35 feet, R5B multiple dwellings at 40 feet. Perhaps R6 at 40 feet and PA at 38 feet would be more suitable for inclusion. I've heard several reasons for the previous existing inclusion of R5, specifically to potentially fill dead zones, to satisfy legal requirements, to not be overly restrictive, to accommodate the non-conforming status of Radnor House. Would not the language in 280-170 suffice for this pre-existing facility? I think it would benefit the Radnor Township Planning Commission and the Communication Council to understand and then communicate to the public the reason for the inclusion of R5. Rick Barker, 920 Lewis Lane, Rosemont, Pennsylvania. Okay. I believe you did adjust language with 280 to address Mr. Barker's first concerns, 164A.
I think, in fact, Bruce, and let me know if you concur, but I'm not opposed to striking the language that Mr. Barker suggests be stricken, just because it is, support structures, as they have been defined in the code, would not. No, there's no overlap. So I don't think that there is, because anything that's existing currently will be grandfathered. I mean, there's nothing we can, nothing that we can do about if there are any existing uses of that sort. So I'm not opposed to striking that language that he's suggesting.
164A talks both about existing support structures and attachment structures. And an attachment structure is something which is really not designed to hold wireless communications facilities, whereas a support structure is. And so I think you really need both. You're talking about both things. You're talking about a building in the one case, which is an attachment structure, and a support structure. You're talking, for example, about this tower that's out here in the back.
And since this letter was written, you added existing support structures.
Yes, yes.
Instead of just support structures, it's existing
So
support
you're really
structures.
talking here about buildings and existing towers.
I'm sorry, that's right. Support structures is in this section so that, as is going to happen, I believe, T-Mobile can add an antenna to the existing tower behind this building. That is a support structure that's existing today, and they will be co-locating or affixing a new WCF onto that. The concern about the potential for new support structures in those designated zoning classifications, I don't see that as an issue because 164B pretty well puts a fence around those classifications where new support structures can be constructed.
Okay. And then his comments regarding the R5.
That gets,
You had touched on that earlier.
I don't have any information on the legislative history that resulted in R5 being included when the original code was enacted 12 years ago, 13 years ago, some time ago. Okay. And certainly to the extent that we have a residential district that can permit the construction of these facilities, we're that much less likely to a challenge by a carrier who is going to make the argument that we are somehow denying them the ability to provide service in the township. And again, we strike the balance of how many opportunities do we want for carriers to have to provide their services, to fill in holes, to reach residential and non-residential classifications. So that's my thinking on R5, and I don't envision, I wouldn't envision a change removing R5 from the amendments.
Dan, do you have any comments, questions?
I just had some things that we had talked about right before Christmas.
Which I was going to bring up. Okay. I'll just go over a few things. Does anyone else have any questions, comments, concerns? I'm going over language, boring stuff.
Well, can I just bring up one more time that I don't think it would affect the proposed changes to this particular ordinance, but because of the importance of streamlining the review process for the applicants and having everything go only to the CCC, I would like to find a way to make sure that there are, in future, design professionals either available to the CCC when they're reviewing this or appointed to the CCC when those appointments are made. I understand that there are people now who understand the issues and they're aware of the design issues and are working towards that, but if the design review board is not going to be in the loop, and I can understand the reason for that, I'd like to see them either have somebody working with the CCC or have some other design expertise input at that level of review.
Yeah. And I think Mr. Ellinger's point about language in the code encouraging the reviewing body, whether it be zoning hearing or CCC, to take advantage of design review in instances where it considers it prudent, can certainly be added here so that at least it's clear that the wish is there that if there's a design issue that can be opined on by more seasoned reviewers, that we should be encouraged to take advantage of that. So,
and if we could beef up that wording, I think that would be good. I realize that there's nothing in the ordinance itself that's going to speak to the, who is on the CCC. You know, who, that's not part of this ordinance. It's something I want us to keep in mind as a township.
You know, so, I mean, you possibly could put the language back in there with the design review board and add something to the effect of, you know, in the event that time permits. I hate to, you know, again, it's vague, but I mean, something along those lines where you really can't, because at first thought I was thinking that you'd, you know, the design review board would be invited to attend the CCC meeting, and I could only imagine the length of that meeting.
We're known for our brevity.
But I agree, there is, you know, it is a concern, and these aren't the most beautiful things in the world, but obviously they're an evil that is necessary.
When does the clock start on the 90 days?
When a completed application has been received by the township.
So why can't we state that it has to go to the design review board before the application is submitted? So
No,
when
you can't start a clock running. You can't force an applicant to do anything until an application is actually submitted, because we don't have jurisdiction to make them do anything until an application actually hits.
Current 90-day period, can you do that? I don't know how long it takes the design review board to act.
Suppose we were to do this. In 280-171B, I guess it's it's 280-171A1, which, these aren't numbered. If we added a sentence that says, notice of the application shall be sent to the chairman of the design review board, which makes sure they know that there's an application pending, they know what it is, and they can come either to the CCC or to the zoning board or to the commissioners and express their views.
Well, how do they have an opportunity to review the application? Do they
Well,
in session? I understand the concern about adding another layer here, but the reason for the design review board, in part, of course, is to bring some order to the thoroughly democratic process that would rely solely on the public's view and the disparate views of the public. So could we have parallel tracks here within the 90 days? So that
I'm concerned you get into double advertising, and you really stretch the process out. And in the case of a 90-day application, you just don't have time for that. And again, the danger is that if we exceed this by reason of our own requirements in an application, we lose control of this process. It goes down to media. And we all know what success we've had in media.
Excuse me, isn't the 90-day for existing or co-location?
Yes.
That's
90 days
co-location.
co-location.
So
150 is for new structures.
well, that's
that's a different issue right there. then.
yeah.
Yep.
So co-location, there's less concern, isn't there, for design review for a?
Well, what I was trying to do here by sending notice when it gets complete, then it goes also to design review. If design review thinks they need to have
But they have no power to bring the applicant before them.
A consensus input.
But they have, other than getting a copy from Dan and discussing it by themselves, they have no way to bring the applicant before them to have the kind of dialogue that would occur at one of their meetings.
I like to think that the CCC is sympathetic enough that if the chairman of the design review board says, we have serious design concerns with this, that those design concerns are going to be aired fully at the CCC.
If your proposed language added something to the effect that that the council would take under advisement concerns expressed by the design review board, then I think we're getting there.
Okay, we can do that.
Can I just comment again, though? But co-location, there's already something there. It's already ugly, so to speak, there. It's just another antenna. A new installation is 150 days. Couldn't we, in the statute that we're proposing here, have the design review for new items and not for co-location? So we'd always be in the 150 days, which should give us enough time to get through.
I have a quick question. Coming in tonight, has Design Review Board been made aware that they're being taken out of this process? Because I could imagine them coming back to us and saying, why'd you take us out of the process?
And I'd give them the same answer that we've given to you tonight, which is the time frame for at least, one segment, but frankly, I would suggest all segments of these applications has been shortened. And the sense that, certainly they will have the opportunity to consider the removal of them from the review process when it goes to the Board of Commissioners, if it is approved by this group.
John, I think there is a way, getting back to Skip's, with the 150-day, that's a pretty long period of time. I understand the co-location, the 90-day, you're button heads on that one. But isn't there a way that on the D2 that you could basically put in, add back in, let me just get the specific section, I apologize.
I think it's
164D.
Yeah, D2.
D2?
Yeah.
Couldn't you add back in applications for wireless communication facilities
Well, Mark, I hear
under
where
164B?
Mm-hmm.
Because they're the ones that were really,
First, I think I would probably add it back to 171.
Yeah,
The
carve out.
section that talks generally about.
Carve out the co-location. I think that's one way. I think that would probably get all of our concerns under. Co-location is one thing. There's already towers there. There's already something there.
Yeah.
But
Are
I think
providers of similar services being treated disparately based on the nature of the application?
No, because one is for a new structure and one isn't. And so I think the way you could do this is to incorporate something like the language we previously discussed and say, in the case of new structures, the design review board shall.
Or there shall be review by the time.
Well, you've got to put a time limit on it.
Right.
Because if they take 60 days, and then you got another 30 days,
Mm-hmm.
and then it goes to the commissioners and.
What is our zoning?
board.
What is our zoning notice, Dan? What's notice under our zoning code for?
The distance?
No, notice
Time.
time-wise.
30 days?
Is it 30 days notice? 45?
I'm not sure what it
I
is.
didn't mean to throw you a
for
zinger,
this
buddy.
Specific. Under subdivision, it depends on what the application is, so I'm not sure how it falls with this
Dan?
type
Okay.
of situation.
Would 40 days be enough for DRB to
Oh, I would
review
think
it?
so.
Review it and
Well,
comment?
that's only going to give them one chance to look at it. So if they have an issue and they want
Right.
them to come back, that's
But-
when you get into a problem.
But then they come back, then I would think they would come back before the CCC.
But at least then the design report has seen it and comment.
Right.
Yep.
And any issues have been aired.
Yeah, I think, you know what, I agree. I think that you almost have to, you put it down. You put design review board first, then the CCC, then zoning and/or
For new structures.
for new structures.
And are you all comfortable with 40 days for the DRB?
But instead of using the term new structures, I think we should use applications other than co-locations, because that's the wording that they use.
Yep, I was using new structures as a shorthand for.
Thank you.
And not to go back into ancient history, but you'll recall back in September when we discussed the comments from the Delaware County Planning Commission, there was some confusion in their mind prompted specifically by the old language relating to design review as to who was actually approving
Right.
the application, because the old language relating to design review said that applications are subject to the review and approval of the design review board.
Review and comment.
Yeah. So,
and that's what one of my concerns reading this, and this is something that I don't think is going to hold us up tonight, but throughout, and I don't, it would be a global comment, but I think we need to tighten up, and again, this is going to be something we can move forward because the solicitor is going to put this if we go through with this and the solicitor then puts it in its final, our solicitor then will put it in its final draft form to go to the Board of Commissioners. But I think some places you put approved by the township, some places approved by Radnor Township. Okay. I think there does need to be a little bit more specificity as to what body is doing that, because Radnor Township is vague. And also in certain areas, make sure that when there isn't specific criteria on the approval, where it just says approved by Radnor Township, since we are in the zoning code, it either has to be by special, if we don't have the specific criteria laid out, we do have to either specify special exception before the zoning hearing board or conditional use before the Board of Commissioners. We just need to that was a global, where we say just approved by Radnor Township, we need to make sure that we have the specifics of what body and by what mechanism is being done.
Okay, and Mark, in the sort of the introductory language to either 164A or B, which is, or 165, we at least do specify either special exception in the case of 164B or by right upon approval in 164A and in 165. But you're suggesting we need to go further than that?
I think in certain areas you just...
because I think some of that language may relate back to the type of application that it is.
Where it just says Radnor Township, a lot of it, approved by Radnor Township.
Yeah, I have the Radnor Township.
What's Radnor Township?
Right, okay. But in terms of the mechanism, whether it's special exception or conditional use.
And I'll talk to John Rice about that, and that's one of my, when he goes through a final draft, just to make sure that everything is either linked to specifics or to conditional use or special exception. Or, the approval process is linked somewhere along the way.
Okay.
Couple things, going back to the beginning, 28161F, and I know you didn't make the change, you made a slight change but brought it to the attention. Shouldn't F basically just say, establish guidelines and standards for the installation of wireless communication facilities instead of within the right-of-way? Just delete within the right-of-way, because since this is the intent of the article, we're governing wireless communication facilities throughout.
Well, A generally provides for range of locations. F gets more specific as it relates to right-of-way. But
I just say it wouldn't hurt us if we just deleted within the right-of-way. I mean, I know you guys didn't put that in there. That's from the original, but might as well clean it up since we're doing this. First, very beginning, intent, 28161. 28162, B, and I know you didn't write this, this article shall not govern the installation of any amateur radio facility that is owned by a federally licensed amateur radio station operator or is used exclusively for receive-only antennas. Well, do we know what that is?
Ham radio.
TV antenna?
Ham radio, I believe.
Well, the first part is certainly, right.
And then what is it used exclusively for receive-only antennas?
TV, remember?
TV.
TVs used to have antennas. They may not today.
Okay.
Not Mark.
The engineer.
Yeah, I got my rabbit ears up there.
Some radios people do shortwave radio reception.
Okay. In one of the definitional section, jump into equipment facility.
Right.
Any structure or enclosure, should we add building? Because building is separately defined, in our zoning code, building is separately defined other than structure and enclosure. So, I mean, building would just cover everything on us if we're covering building equipment facility. Jumping down one more.
Is there something less than a building that an operator might use?
Structure.
structure or enclosure. But building, if he,
Okay, all right,
it just covers all bases.
okay.
In building in addition, add any building, structure, or enclosure. So add the word building.
Okay,
Jumping down below, 3 down, person. I think it's, and again, this wasn't your drafting, this is just cleaning up old stuff. Any individual, firm, corporation, partnership, agency, unincorporated association, or municipal corporation, or agency within the Commonwealth. I think that's repetitive. I don't think we need or agency within the Commonwealth.
agencies twice.
Yeah.
Yeah,
I mean,
Yeah,
I
that's
would take
fine.
out that whole sentence. No, not the whole sentence, or agency within the Commonwealth, excuse me. Delete
Well,
or agency
is there a
within the
muni-
Commonwealth of Pennsylvania.
municipal is modifying agency there? Or can be read to be modifying agency, as opposed to some other sort of agency.
Yeah,
So I think you need it.
okay. I see what you're saying. Right of way. This is one of my, the last sentence of right of way, I know you added it, and I understand why you added it. And then I read the whole thing, and then I read it twice, and I still scratch my head. Is there a better definition? I mean, I understand what you're saying. You're basically saying right-of-way is the vehicular, what we all know as a right-of-way. And I'm just thinking as an attorney, because that's what we do. We try to figure out some way to hoodwink our way into something, and but I just look at the word right-of-way, and I just read that, and it's not include, the last sentence, the term right-of-way does not include any land in which the township holds a property interest that is not a right-of-way as defined above.
Yeah, the comment, this is a Tim Lay change.
Okay.
And the comment that accompanied this change reads as follows. I clarified the definition to limit so that it cannot be construed to include, circular time, non-right-of-way property of the township. The Willows.
Yeah.
Public parks. Other
Okay. If everyone
where we
else,
stand right now.
maybe I just have a block on that one. Is everyone else comfortable with that one?
Bruce knows this intuitively, but it's slow registering with me. How is right-of-way used? What's the effect of limiting the Willows from the definition of right-of-way? It's too late, I'm not.
Well, someone can't walk in and by right put a 60-foot pole in the
So it
middle of the
limits the
Willows.
size. Yeah, all right, okay.
If it were not,
Right,
you
okay.
know, if it were non-right of way.
Is everyone else comfortable with that? Something I read a couple times. I think Dan read it with me too, and we kind of scratched our heads.
Unless it's an existing structure, right?
But if it's township property, the township would need to permit that use, wouldn't it?
Well, the Willows would be governed by 164, right? Because it's outside the right-of-way?
Depends on the type of application. It's the type of application that determines whether you're in 164 or 160. I'm sorry, no, you're right. Yeah. A or B. No, you're right. It's 164, John, I'm sorry.
So, as it now reads, it'd have to be at least 60 feet.
Okay.
Of which there are none. Right?
Right.
So you couldn't put,
There aren't, I'm sorry, there's
there
not
are
a 60.
no, there
There's
are
not
no
a 60-foot structure
in the Willows.
outside? Oh, no, in the Willows, no. But there are certainly 120-foot structures on public property today where,
Yes,
Yeah,
right,
okay.
yep, okay.
Next one I have is in 164A. We are going to delete planned institutional from A6.
that's correct.
Okay. We kind of already discussed the R5 residential, why it's in there. On C, where you say nor exceed a maximum height of 15 feet, at the very end, equipment facilities shall not exceed, basically the height of the maximum height of the facilities. Should we reference above ground level or above, just give it a specific?
I I believe the term height is defined. The distance measured from ground level to the highest point of the wireless communication facility, we can add, or equipment facility.
Yeah, if you, that's probably the
Yeah.
better way, place to do it. If you get back at the definition of height, add in language, equipment facilities. Okay, we already talked about the design review board. On E, Bruce, this is a question to you, and just, I mean, I had circled to give more teeth to the showing of need of new support structures. Evidence submitted shall, and you under, it's really the burden of the applicant, so may would work there, and let them fit their bill. That's that. Got that. Oh, 280-170. In the new language that you added, as of the day of this ordinance, existing wireless communication facilities will not be deemed to be conforming facilities under this ordinance if such facilities have been altered or modified without any required. Dan, that's one from you, and what were we?
I missed which section you were reading.
280-170. Yeah, 280-170. It's the new language that was added, the underlying.
Yeah, I was having a problem with the double negative.
Yeah, that's, as of the day of this
And
ordinance.
I thought we should take out the not and make it,
Oh, will be deemed non-conforming facilities.
right.
Will not, okay, yeah. So instead of, as of the date of this ordinance, existing wireless communication facilities will be deemed to be non-conforming facilities under this ordinance.
Okay.
No, then you need the double negative. It needs to be will be not non-conforming, because they're saying if you don't, if we don't.
What this is.
I think you actually have to have non-conforming in there. I think it has to be a double.
Would not,
It has to be, because
would not
a
be deemed to be
non-conforming facility is yeah.
under this section.
Yeah,
How's
a non-conforming facility is a legal facility.
It won't
that?
be.
It doesn't get protection. if you s-
Exactly,
if
and
you
that's,
strip
and you're
it
actually
out.
giving it protection, so you need to add, facilities will not be deemed to be non-conforming. You do need to,
And if you put under this section, that makes it clear that it
We're only
exactly.
talking
goes back
about,
to the first
You okay with that,
section,
Dan? Is that,
first sentence.
I think you need to add the non-conforming rather than the not, yeah.
Everybody knows what we're trying to say, and
Yeah.
if you played around with it without the necessary permits, you don't have the protection anymore.
And then lastly, I have on 171, 280-171, A4, just to make sure it's clarified that the applicant, just start it by saying applicant shall provide notice of an application. So really put applicant, make sure the burden is on the applicant, because I believe that the township now is under the position that applicants do all the noticing. And that's all I have. Dan, do you have anything else?
My preference was to leave this whole section out and rely on what's already in the zoning code, so that it's already in section 280-142G about how to notify.
The problem is, Dan, we don't have that for stuff that is on township property or in the right-of-way.
I'm sorry, say that again?
We don't have, the zoning code doesn't apply to township property and stuff that's in the right-of-way, and we want these provisions to apply to them as well. It's not only,
yeah, I
it's not
think,
only
All
where
right.
you
Okay, I
have
see
to
what-
go,
okay.
I see
it's
what
not
you're
only where
saying.
you have to go to the zoning board.
Okay.
All right.
yeah, I mean, the
The example I can think of is the facility that was proposed for Bryn Mawr Avenue near Malin Road, and I believe was before the Board of Commissioners, and I think former Commissioner Hervada made the point eloquently that no one near that proposed facility would have received notice, and that's what we're trying to avoid. And obviously, we're appending the much of the procedure that's already in the zoning code for matters coming before the zoning hearing board, and we're just using that as the notice mechanism for everything else.
That speaks to Sarah's concern earlier, that now everyone, no matter what, when it's a wireless, all the neighbors get notice. So.
That's right.
Okay.
My concern was that if we change the distance, the notification distance in the existing section of the zoning code, this might get missed, and it might be a different coverage area. I was just trying to be consistent, so that's where I was coming from.
Okay.
Was it 1,000 feet?
Well, it's 1,000 feet except in R5, where it's 500 feet.
Because I think we may have shrunk that for this purpose, but if the suggestion is
No, I would suggest keeping them the same distances.
Right.
That was what, I believe, 2 years ago, we revised our land development subdivision ordinance so that all distances and all timeframes were consistent between all ordinances. It gives staff a little bit of a leeway over there.
Okay.
Because then we'll drop, something will get missed.
Yep.
We send it to the wrong.
Exactly.
Okay.
Okay. Does anyone else have anything?
We talked about 28165 1, shall not exceed 60 feet. Do we want to change that?
Yeah, I mean, I think.
I believe we've agreed, well, we haven't,
The one thing we do want to do, I certainly, there's no objection from us on reducing that height limit. We do want to, just to get a quick reality check from Tim Lay in Washington to get a sense of, it's limbo time.
And
how low can we go?
What height are we going to, 45? 45 is, okay. Ed, wanted in 45, subject to confirmation from the FCC council that it's not too low. Anyone else? Okay, can we make a motion to send this to the Board of Supervisors, subject to the following? Ed? Board of Commissioners, excuse me.
Yeah, I'll make that motion to send this to the Board of Commissioners for approval, subject to the following. I'll go real slow. 164D2, we want to add back the language requiring that for new applications, it does go through the Design Review Board, which will have 40 days. In paragraph 171A1, we want to add language that says that all applications will give notice to the Design Review Board. In 280-165A1, we want to reduce the maximum height to 45 feet, subject to the FCC, I guess we want to say, opinion or
Blessing by council.
blessing, okay. In 280-166J, we want to revise the language to clarify and beef up the advertising to include commercial signage with the exception of signage for safety reasons only. Okay? Globally, we're asking that where Radnor Township is mentioned, we make it clear specifically what agency in the township is giving those approvals. In 280-164B, Doug, you mentioned the definition of property that the township leases. So I think we're looking for a definition of a lease. I think we're okay with the concept of a long-term lease, Doug, but it shouldn't be something that's short if it's a township leased property.
One of the things about having two lawyers on this committee is that we can fight with each other. If the township leases land for 10 years, the only thing it can convey, and I'm going back to the tower that's put up in the 8th year, The only thing the township can convey to the person erecting the tower is the right to keep that tower there for 2 years. Because the township has no right to the land after 10 years.
My question, Scott, I don't know what everybody's time. My question was, does the owner of the land then have, since the tower's already there, does the owner have the ability to retain that tower?
I would argue that the owner has the ability to retain that tower only if he comes back and gets approval under 164.
All right, so we'll strike that. 280, 161F, we're deleting the word right away. I believe that was the end of the paragraph. Somebody help me with that one. 161F.
Oh, yeah, within the right-of-way, the language within the right-of-way.
Within the right-of-way. Thank you, Mark. In the definitions, under equipment, we want to add the word building. In the definition for equipment, add the word building. 164A, we're deleting planned institutional. In the definition of height, we want to add equipment facility. In 280, 170, we want to remove, or I should say rewrite that language so it will read, will not be deemed to be nonconforming. In
Under this section, yep.
Say it again.
Will not be deemed to be nonconforming under this section.
Under this section, thank you. $280,171A4. We want to add that the applicant shall provide notice.
Yep.
And in general, in paragraph 171, we want to make sure that all of the notice distances are equal to all the other township notices, so there's no difference in those. So that's what I have for the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 comments. So with that, I'm making a motion.
Just had one question about the design review reference, that board. Was that a blanket referral back to design review, or was it just for non-co-location?
Notice for all applications to design review, but design review board would actually get to give comment on new applications within 40 days.
Okay.
Where did we leave the size, the height of the tower?
45 feet,
45.
subject to blessing.
Okay. Any further comments, questions by the commission? Do we have a second?
Second.
Vote, all in favor?
Aye.
Aye.
Any opposed? Very good.
Mr. Chairman, may I make one more comment? I am, in most of the things that come before the Communications Council, there is a lot of drafting involved, whether they be franchise agreements. This particular effort was undertaken by John Riley almost close to a year ago, and he has spent, I think it's safe to say, innumerable hours in the service of this township, working on these ordinance revisions. And I just want to say the Citizens Communications Council owes him a great deal of thanks, and I believe this township owes him a great deal of thanks.
Thank you, John. I was going to say the same. I know you've spent, John and I have exchanged numerous emails back and forth, making sure that all the information, and I know how much you've worked between all the different solicitors. But I know, Bruce, that you also, Bruce Wilson, has worked very hard on this, along with Tom Glynn and Art Hartel. It's Art Hartel of the Citizens Communication Council, and we, the township, for everyone in this township that does as much as you guys, again, we thank you. In the township, it's nice to have people out there that do so much for the township, and we thank you, and it was a pleasure working with you through this. Good. Okay. And now we'll move on to our next agenda item. And we can see the public has aborted. We're going to move on to agenda item number 4, which is a recommendation to the Board of Commissioners, ordinance amending Chapter 280 zoning of the zoning of the Code of the Township of Radnor, Articles 1, General Provisions, Articles 17, FC Floodplain Conservation District, Article 20, General Regulations, 22, Administration, and Chapter 175, Grading, Excavations, and Fills of the Code of the Township of Radnor to all comply with the National Flood Insurance Program and PA Act 166. And Dan will give a presentation on this. I know that I spoke to Dan and I spoke to Sue earlier. I did not get a chance to do it. I did read this once. I didn't get a chance to read a lot of it. I've spent a lot of time on the previous application, as I think a lot of us have. I believe we received, what did we receive your final draft on this on about a week ago?
Yeah, Tuesday or Wednesday.
So the way I'd like to, with obviously the commission's blessing, and I think Dan, why don't we get a summary from Dan, kind of go through the highlights. If we've got any questions, pose them, and then we can table this until next meeting, and we can then get a chance to all of us to digest this ordinance.
Yeah, that's perfect. We're
Okay.
you know, we have a little bit of a time issue, but FEMA's okay. We advertised the ordinance. That was the only thing they needed, so they could put a checkbox in the right box and satisfy everybody. So I think we're okay at this point in time.
Perfect.
So basically, the reason that we're here is we received new floodplain maps from FEMA. I have a copy here on the table, so Jim could turn the camera on. I'll show you a couple of small areas where there's some pretty significant changes. Okay. You have it there? Okay. All right. So we have new floodplain maps. Part of the floodplain maps required some changes in the language of the ordinance. Dealt with some people at PEMA in Harrisburg who are working under FEMA. They submitted some sample language that they wanted to see incorporated into the ordinance. The township solicitor has looked it over, tweaked some things, and basically that is what you have. Can you zoom in a little bit, Jim? Is it clearer on your monitor? It's kind of washed out. So basically what we're looking at in this area is County Line Road at Gulf Creek. So what I did was I took a blow-up of that off of our GIS. We received this in digital format as well. So it has a look on your, can you see the black lines? Yes. Okay, so basically we have some blue lines that are reflective of what is the previous floodplain, and the black lines are what is now the current floodplain as determined. So you can see that there's a couple of areas where the new floodplain is wider than what was previous. This whole stream here is no longer considered a floodplain according to FEMA. So that's one small area where there's a change, and what I have is down at Hunt Road and Bryn Mawr Avenue. Again, here's Hunt Road, here's Bryn Mawr Avenue. So I took our aerial photographs and overlaid the old floodplain and new floodplain, and there's a home shown right here where it is clearly out of the floodplain in the old maps, and now half the house is shown to be in the floodplain. Similar thing is in here. It's not quite as bad, but it's gotten a little bit wider. And over on the Hunt Road section, there's a couple of areas. You know, this tennis court now that's back in the woods is now completely in the floodplain where before it was not. So there are a lot of areas throughout the township where these changes have come up. So one of the things that the township needs to do, and that's one of my department's charges, is to notify everybody
where there's been a change on their property to make them aware that this has happened, so that if we do get another Hurricane Floyd, they're not surprised when FEMA tells them, well, you should have gotten flood insurance. So at least they'll have a little bit of time to work on it. So I'll go over real quick what I sent to you, because there's a lot of new definitions that I think are pretty straightforward. One of the things that they're talking about waterproofing basements, making sure electrical panels are at least 3 feet above the flood elevation, the 100-year flood elevation, or I'm sorry, now they call it a regulatory flood elevation. We got rid of the word mobile home and put in manufactured home. We have a lot of Department of Environmental Resources in the language. Now that's changed to Department of Environmental Protection. One of the things that, I'm looking for my note here. I'm the wrong one. One of the things that we heard back from Delaware County when they reviewed the ordinance was to notify the residents, as I mentioned previously, about some changes on their properties. And what else was there? There was some language about prohibited uses that they wanted included under section 280-77. So I'm in touch with Mr. Rice to make sure that that gets incorporated. So I'm not sure if there'll be a change, because there is some language that exists now that talks about prohibited uses in a different section. So I'm not sure if Delaware County missed it or if they're looking for better clarification. I'm sorry, what was that, Doug?
You're referring to section 4-287-77, prohibited use.
Yes. That's really it in a nutshell. A lot of it is definitions that they wanted added.
Dan, any effect on any current applications in for zoning or subdivision or additions or anything that may be affected by these changes in either of the areas?
Well, not these areas, but there's probably going to be several hundred properties that are affected. Some are going to be in better condition, that is, they're out of the floodplain, but there will be others that will be in the floodplain. We probably get 4 or 5 lomas from the FEMA where a resident has applied and gotten approval or been deemed to be outside of the floodplain, so they no longer need or mandated to purchase flood insurance. I got 2 in the last couple of months where people had hired an engineer and they went out, did a survey, documented that the structure is out of the floodplain. So that's probably the situation that these residents will have to do, is where they'll have to spend some money and either prove or bite the bullet and purchase flood insurance to protect themselves. And part of what prompted this was, I guess it's probably about 6 or 7 years ago, there was a change at the federal level where people who even refinanced their homes and lived next to a stream found out that they are now required to get flood insurance. So that a lot of people were caught off guard with that.
Dan, how does this new map compare to the study that Pannoni did for the township in terms of expanding some of the areas where we knew there were problems as it relates to some of the stormwater issues. And it looks like they've expanded some of these areas, particularly Gulf Creek. And what is the other body of water at the bottom of the map that you have?
Well, this is part of Brown's Run, which connects with Ithan Creek and eventually connects with Darby Creek.
Right.
So Darby Creek is on the western edge of the township, Gulf Creek's along the northern edge, and Ithan kind of splits the middle. So here's more of Ithan Creek as it comes down the middle of the town, paralleling the Blue Route. But to answer your question, what Pannoni had done was they had gone into some isolated areas and tried to look at some, I don't want to say quick fixes, but some places where repairs or enhancements could be done that would mitigate flooding. So the majority of those suggestions have been completed. Some areas have seen improvements, some areas have not. Between that and our updated stormwater ordinance, where we are catching everybody who comes in and is adding more than 500 square feet of new or reconstructed impervious. They're required to do a seepage bed. Over 1,500 square feet, it's required to do stormwater management with rate control. So I just updated our files today with the most current information. We have about 780 properties that have stormwater management on them. So the next challenge is making sure they're working the way they were designed. Right? So, we have them. I was out at a property today that it's an above-ground basin, so it's a little more visible, and I don't think anyone's looked at it since it was installed 20 years ago. So, some of the outfall structures are silted in. There's trees growing in the middle of it. So it's one thing to get them installed. It's another thing to make sure that they keep functioning the way they were designed.
But this particular change is just specific to the new, is it the FEMA?
Yeah, this is our flood conservation ordinance.
Right.
Floodplain Conservation District.
But you're
ordinance.
just updating it to match the new code from FEMA.
Yeah, this is suggestions that came down from FEMA that are in conjunction with these paper maps.
How often does FEMA update their
The
floodplain?
last ones were from the early 90s.
Okay.
And there wasn't a whole lot of change. It was more they added roads. So the actual floodplains did not change much.
In the last one?
Yes.
The areas that have changed in this one that you mentioned, there's a house now that's half in the floodplain. What is your sense from your experience? Are these areas that flood? Is this map more accurate?
From what I see, yes, that it is more accurate.
I mean, no map is going to be perfect, but...
Yes,
yeah.
It's not perfect. And it changes. We had I guess it was 2-3 weeks ago, we had a long, not a real hard rain, but it was a long, sustained rain. The ground was frozen. We had some snow melting. And, that area was very flooded. It's very similar to what was, there was a storm before Hurricane Floyd that was not as bad in some areas. And that reminded me of what we saw then, even though it did not rain that hard. But the ground was frozen, so nothing was being absorbed and everything was running off.
So even though there's going to be perhaps an additional, need for people to get flood insurance or due to the change to this map, it's probably a good idea. It's moving in the right direction, you feel?
Well, it's certainly letting them know that they may face a problem
Be in that
the
situation.
future. So at least it makes them aware that there's a situation at their property that they may not be aware of now. Even though, if they look out the window and they see the stream, it should catch their eye. And I had a similar situation where, not too far from here, joining Township, a resident filled in the floodplain. And now Radnor's residents are seeing a change on their property. It's not affecting the home, but it's affecting their backyard. So you know, we're dealing with Marple and the property owner in Marple to address that. But
And on a related topic, this board over the past, I guess the past 2 years, a couple times have looked at applications that have come in for land development where I think in both cases it was parking lots or were cited partially in the the floodplain, the 100-year floodplain.
yes,
And we talked about how the township's requirements for those properties was different than, you know, other townships perhaps. And it had come up at that time that perhaps we would need to review that part of our floodplain conservation district ordinances. Is that something we should think about now because of these changes that are happening? Is it better to do it all at once, or is it your opinion that it's best to deal with this ordinance to meet FEMA's requirements for their new map, and then in a separate issue, deal with possible changes to the floodplain ordinance that would better reflect our protection, our desire as a township to protect that resource?
no, I think now's the time to do it. We should make the changes that we think are appropriate and get those instituted. So I think you're talking about the property down on Conestoga Road near Sprawl. Is that the one you're referring to down in Ithan?
Yes.
Okay.
Weren't there two?
That was the O'Neill property, and was there another one? Yeah, I mean, the situation there was there was a couple of structures in the floodplain, and his proposal was to raise those two structures and build a new structure. So the change in the floodplain was, his position was he was not changing the floodplain because he was removing some obstacles, but he was still putting a new obstacle in the way, so he was not changing the elevation of the floodplain. And that's basically what this language talks about.
Okay. I don't know if it was the same application or not, but there was also a parking area where we talked about how the parking lot, the proposed parking lot, went down towards and into the floodplain. And we were even talking about, you know, are there different designs for the parking lot so that it doesn't get undercut by floodwaters? Where common sense might tell us that perhaps we shouldn't be building parking lots in the floodplain. But it wasn't, our ordinance did not protect us from that at that time.
Right.
And of course, that application is, we're done with that. But moving forward, I think we need to look at that now.
Okay, good. Yeah, I think this is the time to discuss those and
Great.
come up with language that we think is appropriate.
Questions, comments? Motion to table this till next board meeting? So moved. Second?
Second.
All in favor?
Aye.
Aye.
Okay, next on the agenda, new business. Any new business? Any old business? Motion to adjourn?
So moved.
So moved. All in favor?
Aye.
Thank you very much.